there, I'm Heather Gill, local realtor here in DFW with eXp Realty, and I am talking to Jenna Zebrowski. She is the principal attorney and the owner of Law by Jay-Z. Thank you so much, Jenna, for hanging out and answering some questions.
Hey, thanks for inviting me. It's always fun.
Absolutely, I love it. So we had a question come through texaselder.care, and it's this. I gotta hear what you're gonna say. So, how do I transfer the deed to my house to my son or daughter without a will? What's going on here? What do we do?
Well, I'll give you the lawyer answer, which is it depends, right? This is a very situation specific question. So in this case, I'm assuming that this person is asking for him or herself, so this person is still alive and they're trying to make some plans. If this person is already passed and the son or daughter is trying to find out, well, the ship has sailed on that one. There is no will. We'll have to plan accordingly. So in this case, it's, again, very situation specific. Are you the owner of the house, or is there still a mortgage on it? Do you plan on continuing to live in the home after you transfer ownership, or are you leaving, or is the child moving in with you and you'll all be in there? I do not, there's also some tax consequences as well. So, for example, I wouldn't necessarily recommend, if you're over 65 and have the homestead tax exemption on the property, I would not suggest putting your son or daughter who is under 65 on that, because then part of the tax exemption is lost because that person is going to be on the deed and it's done in a proportion ownership.
Oh, wow.
So this, again, can it be done? Yes. What are your goals? So if you want to keep the property and live in it for the rest of your lifetime and then have it passed to your child, the best thing really is to create a will. There are ways to make that easy and cost efficient, and then you don't have to worry about transferring the deed. All of this is taken care of in a very administrative fashion after your passing. If this person is still alive and wants to transfer the deed while they are still living for whatever reason, there's several different ways that it can be done through a combination. You could sell the house to the child, absolutely, for the balance of the mortgage. You could do a gift and equity. You could do a lot of things. So we really need to kind of unpack the situation and see if they want to stay in there or if they're looking to get out, and also kind of explore some of the financial aspects. There could be tax consequences. Property taxes and homestead, as we all know, is very important in Texas. And there's also income tax implications and gift tax. So those are all important. What I would suggest is, this is a great question though, because you're still alive and you're trying to plan for it. So let's have a conversation about that and see what your end goal is. And then we'll figure out the best way to effect that transfer, whether it's through a will or another method. A lot of different pieces of the puzzle before we can get to this specific situation. Right, Heather?
No, absolutely. There's a lot to consider, a lot to look at, and Jenna can definitely help you if you have questions about that. So let me put her information on the screen. You can shoot her an email, or you can go visit her website where you can go ahead and schedule that free consultation with her. She'd be happy to talk to you more about this. Jenna, I appreciate your time.
Of course. Thank you so much for having me, Heather.